Best practices for virtual court and legal proceedings. That's the subject of today's ACTEC Trust and Estate Talk.
Welcome to ACTEC Trust and Estate Talk from the American College of Trust and Estate Counsel, a professional society of peer-elected trust and estate lawyers in the United States and around the globe. This series offers professionals best practice advice, insights, and commentary on subjects that affect our profession and clients. And now, our ACTEC Fellow host with today's topic.
This is Travis Hayes, ACTEC Fellow from Naples, Florida. During the pandemic, virtual hearings and procedures became commonplace. ACTEC Fellow Lee McElroy of Palm Beach Gardens, Florida, joins us today to offer best practices and advice for these relatively new types of court proceedings and legal procedures. Welcome, Lee.
Thank you, and welcome to the podcast. I'm going to jump right in it, and I feel like that's the appropriate thing to do for this topic because when the pandemic came around, we were all thrust into this new world. And what I mean by that is I'd always gone to every court proceeding. I was always in court, in front of the judge, with the clients in the depositions, in person. Maybe a phone depo, maybe a phone hearing every now and then, but we've entered into a totally new world with online court, online depositions, web-based depositions. And so starting in that March of 2020, we've now had almost 3 years of experience, and I've been fortunate or unfortunate enough to have at least 3 online trials completely over Zoom. 1 one-day trial and 2 5-day will contests. I've also done innumerable mediations and depositions online over different platforms, whether they be Teams or Zoom. And today, all I hope to do is just present you with some options for how to present best practices and to make sure that your side's analysis, your information is presented in the best light possible to your trier of fact, or you can take the most effective deposition that you can. And that's really what I want to focus on. And Florida was definitely at the forefront of this, allowing this technology to be pursued. And in fact, in the county where I practice, if you have a court hearing under 2 hours, it's going to be presumed that it's going to be over the Zoom platform. So practitioners are being forced to adopt these things. And so let's start with the most basic and fundamental. Have a good setup. Test your microphone. Test your video. Make sure you don't have an inappropriate meme or covering or background when you start this process. Check it before the hearing. If your hearing's at 8:45, you don't just walk into the courtroom at 8:45. Make sure your platform is up and running at 8:40 because the last thing you want to do is you ready to start your hearing and Teams has to update. And now you're late for your hearing and the judge is wondering what you're doing and why you haven't logged on yet. And while we're talking about the different platforms, that's a whole nother topic. Over different counties, different judges have liked different platforms. So you need to be familiar with each platform, whether that's Zoom, which seems to be the most common for my particular practice, or Teams or WebEx or whatever other platforms out there. Make sure you know what that platform is going to be and you have some familiarity with it. And again, for me going in, it was definitely a trial and error and seeing what other good attorneys did to prepare, how they set up their documents made a big difference. And that's what I hope to present to you as part of this. So I think with every time you say, I'm going to appear before my court, what should you do? Read the court's administrative rules. Read that, whatever you can find out about that judge. Does he or she have a particular preference on how they like people to appear? Do they use Teams? Do they use WebEx? Do they use Zoom? Do they want the documents sent to them ahead of time via email? Do they want them uploaded to a portal? Or are you able to just share your screen? So that seems to be the most common one for me, is that we end up sharing our screen a lot. And a lot of times people will try to access documents from different platforms, whether they've got a jump drive or they're connecting to their server through a laptop or whatever system they're using. My personal preference, unless it's hundreds of documents, is I'm going to have my documents not only loaded on whatever particular device I'm going to be using, I'm going to open them ahead of time. And they're going to be on my screen in different tabs. And so when I go to share, I know my document's there, I know where to go, and it's already preloaded, and my computer doesn't have to take that extra step to access my server and take extra time or slow down the connection. Because obviously, all that leads to frustration, problems. It goes back to make sure your setup's correctly. So we're talking about how your computer's set up. What about where you are? Now, listen, we can't always stop the people from outside from doing, lawn work or cutting bushes, but you can try to do your best. And, if you're going to be in your home, make sure you don't have the dog running in. Make sure you don't have kids running in. Make sure you're dressed appropriately. You're still in court. Even if you are not going to be on screen or they can only see the top of you, make sure you're dressed appropriately because you might have to stand up to get a document and heaven forbid you don't have the appropriate attire on below your waist. So again, just simple basic things you can think of and do ahead of time to prepare. Beyond talking to the court, making sure you know what the court wants, I would say the second most important thing, talk to your opposing counsel. If you know your opposing counsel, if you can trust your opposing counsel, it will make things infinitely easier. You can share documents, you can clear documents ahead of time, you can exchange exhibits through Dropbox or other large file sharing services, and you can get it all out there and you can share it with the judge. Now, when it comes to a trial, obviously you're going to be having a lot more documents than normal. And I find that while some judges are very technologically savvy, it's still easier to actually practice if they have paper. So for the 2 large trials that I did, in addition to sending the judge every document electronically, I actually prepared tabbed binders so that if I said, Judge, I'm going to exhibit 15, she could simply go to the binder, turn to page 15 and look at the document. So she doesn't have to take up whatever screen she's got with the document, can still see what I'm asking about. It makes it so much more effective to have your presentation so the judge knows exactly what you're doing and where you are. So again, it seems it's an extra step you need to do because before we just send that and now we're uploading it on our computers, but it is a more effective practice. And actually, the Zoom tools, I say Zoom because I use that the most, actually allow you to make very specific points if you can use correctly. Again, if I'm on Exhibit 15 and there's a particular section that I want to hit, I make sure the judge has it in front of her, and then I can share my screen, and then I can use the functions to highlight a specific section that I want the witness to focus on. And again, when I've shared my screen, it's blown up so that if the judge is looking at it, it's highlighted. I can focus the opposing party's attention on it and really use it to emphasize that point home. So rather than just hand the document to the judge, say, look at Exhibit 15, I got it in front of her and I can highlight it. So there are some real advantages to not just appearing in person and actually using these platforms for better purposes. And obviously, when you're in trial, you're cross-examining a witness, it's a very different process than if you're live and in person. You're looking at somebody through a very tiny window. If you're sharing a screen, you might have 2 inches of space to see them. Again, you need to be extra prepared to have your documents ready to go because it's not an instance of where you can go grab a document. You have to have it all preloaded, all ready, so that you're able to actually make an effective cross-examination if that witness goes off script. For me, all my cross-examinations, I've got their depot tab or whatever document I'm going to use to impeach them if they go off script. And so that I know if they go off script, I just simply open the document, share screen, and refer them to the proper exhibit. Again, it's small things like that that will make the process faster and make it better. Just overall, forget depot, forget trial, but anytime, make sure you have a good setup. Make sure your mic works. Make sure that you can hear. A lot of people have talked about the need for a backup. One of my clients was being deposed by a very good opposing counsel. My building lost power. It wasn't just that my computer froze or anything. My whole building lost power, completely shut off. Now, fortunately, I knew opposing counsel and I simply called him immediately from my cell phone and said, you got to stop. I'm completely kicked off. I don't know when I can get back on. But if you have a really important hearing, a lot of attorneys will sign on through 2 computers just in case one doesn't work. Or they have their cell phone next to them with the Zoom or WebEx loaded, ready to go if they have a bad connection. So again, you're trying to make a good impression on that court. You're trying to make a good impression for your client against the other party. You need to have your bases covered. Now I'm going to shift topics a little bit and talk more specifically about either some deposition or trial tips that will help. For the depositions, one of the biggest concerns that I have for any Zoom or online deposition is I don't know who's in the room. So I want to start and talk about what I call the best practice. And then we can go down from there in the order of what you can do to mitigate problems you might have. Best practice, have the court reporter in the same physical room as the witness, even if nobody else is there. That way, the court reporter knows if they're checking their phone, if they've got documents in front of them, if they're communicating with anybody. You have somebody, a third party, eyes on that witness who can see the entire room. I think that is critical because a lot of times, even witnesses who you might think know better don't. And there will be people in the room. They will have documents in front of them. There was a Florida lawyer sanctioned severely for texting with his client during a deposition. And he was only caught because somebody noticed that the witness kept looking down in a certain direction. So you need to be cognizant of those issues. And the best way to nip that in the bud, have the court reporter present. Now, if the court reporter can't be present, what's the next best thing? Have that person who's being deposed take the camera and do a 360 of the room to show everybody who's in that room. So you know everybody who's there. It doesn't mean, again, you can't prevent somebody from sneaking in, but that's the practice. And then when you go on the record, ask them under oath, do you agree nobody's present, that nobody has come in since you've shown the room, that you don't have any documents other than those that are here for the depo in front of you, that you're not communicating with anybody, that you're not going to communicate with anybody. Again, all you can do is try to mitigate some of these things that would be more obvious in an in-person setting, but those are better than doing nothing at all. Because the problem could be if you don't do that, and it turns out you learn they were communicating. If it's a third-party witness, they say, I didn't know any better. Nobody told me that. You're not going to have the same effectiveness in going in front of the judge and asking for some sort of sanction versus if you said, listen, you agree you're not going to communicate with third parties. You agree nobody else is in the room with you. You agree nobody else is providing you with information during this deposition. So again, hands down best practice, have the court reporter be there, even if neither of the attorneys are there. And if the court reporter can't be there, have them show the entire room under oath and then walk them through a number of questions. And one example I've seen is have the attorneys enter into a stipulation about how those depositions are going to proceed. What's going to be done to make sure those witnesses aren't communicating with third parties. That's an excellent way because that way both attorneys, all parties are on record with the court that yes, we agree this is the process we're going to follow. And if they don't, everybody's liable to sanctions from the court. Now, in talking about depositions, that brings to mind, well, if you're taking a deposition or defending a deposition, when I defend a deposition, even if it's going to be Zoom, I'd prefer that my client be with me because, again, it's just easier to do everything. And again, be very open with opposing counsel. I let them know, yes, they're in my office. They're just on a different device. Everybody can see everybody. Everybody's ready to communicate. But it's easier to practice that way versus if they're on another device in another location, it's just more difficult. And again, goes back to how you set up. Some people just want a simple headshot. Some people want a broad view of the room. I've seen at some of the larger firms, they have these large conference rooms with these giant tables and the camera's set up on a screen at the far end. Well, sometimes that's actually counter-effective because it's so far away, you can't see when that attorney is communicating. And it's hard to understand when she or he is done communicating or presenting whatever they're going to be doing. So make sure your camera setup is good. I think the last thing that I'll talk about for this is just a tip of consider sort of an IT specialist if you're going to have a significant trial, a multi-day trial, where you're expected to conduct everything over some sort of online or web-based platform. Or and you're presenting evidence and you're making sure the exhibits are running and you're making sure everything's getting in. The last thing that you want to be worried about is that kind of stuff. You should be focused on your case. You should be focused on, is the evidence that I need to get in admitted? Are the witnesses testifying the way I want it to go down? Am I impeaching the people that need to get impeached? Are my arguments ready to go? Am I paying attention to make sure evidence is properly excluded or admitted? Consider bringing in, an IT person to run your Zoom platform. Make sure that everything runs. Make sure there's a backup if your connection dies. Make sure that all your exhibits are good to go and you can simply say, go to exhibit 15 and you don't have to sort through and do it. For me personally, when I did my trials, I was comfortable using it. I was comfortable doing it, but that's just me. Everybody's got a different level of comfort with whatever platform they're using. And I would suggest for what a trial costs, if you're going to pay a tech person, $100 an hour to maintain it, it's worth its weight in gold to know that you don't have to worry about it. So anyway, those are just some of the things that I think would help be best practices for you. And I want to thank everybody who, from my group, who participated, who really supported this presentation. And thank you for your time.
Thank you, Lee, for discussing best practices and tips for handling virtual court and legal proceedings.
Thank you for listening to this episode of ACTEC Trust and Estate Talk, the podcast series about wealth planning matters from the American College of Trust and Estate Counsel. To find an ACTEC lawyer near you, visit actec.org. Please subscribe to this series and leave us a rating or a review.